Good evening and welcome to RFL. I'm Richard French. In the next hour, a possible new roadblock from Democrats for Biden's big infrastructure plan, the latest on embattled Republican Congressman Matt Gaetz, vaccine passports, and much more. But we're going to begin tonight in Minneapolis with the Derek Chauvin, George Floyd murder trial.
Sir, do you have an opinion to a degree of reasonable professional certainty to how much force was reasonable for the defendant to use on Mr. Floyd after Mr. Floyd was handcuffed, placed in the prone position, and not resisting?
My opinion was that no force should have been used once he was in that position.
That was LAPD Sergeant acting as a prosecution expert on police use of force in the Chauvin murder trial. Now, speaking to what seems to be the essential question right now in this case, was Chauvin's knee on Floyd's neck an acceptable use of police force to restrain a suspect that, as mentioned, was handcuffed, or was it murder or manslaughter? In this Minneapolis courtroom today, the main line of questioning focused on police use of force. Prosecutors calling Los Angeles Police Department Sergeant Jody Steiger back to the stand. An expert on the topic testifying former officer Derek Chauvin's actions were deadly and that George Floyd did not appear to be a threat once handcuffed on the ground.
He was in the prone position, he was handcuffed, he was not attempting to resist, he was not attempting to assault the officers, kick, punch, or anything of that nature.
The defense questioning Steiger's expertise, arguing Chauvin could have used even more tactics to subdue Floyd under Minneapolis Police Department policy.
Officer Chauvin, theoretically, based on what he saw, active resistance, he could have come up and dry stunned him or tased him. That would be within the active resistance, struggling use of force continuum.
Yes.
Defense attorney Eric Nelson claiming the crowd distracted officers from giving Floyd medical aid. But Steiger disagreed, saying Chauvin was aware of Floyd's state and should have stopped restraining him.
Because in the body-worn video, you can hear Mr. Floyd displaying his discomfort and pain, and you can also hear the defendant responding to him.
The Floyd family attorney, Benjamin Crump, speaking out today on The View.
It shouldn't be riveting when we see this. It should be expected that police chiefs and police will tell the truth. And so I pray that we now have a precedent that police officers all over America will step out in front of the blue wall of silence.
Today's testimony continues a prosecution theme, putting people in various positions of authority in the Minneapolis Police Department on the stand. That, as they tell the jury, what Chauvin did was not, quote unquote, by the book and not department procedure. Now, we heard that yesterday from the police chief who later terminated Chauvin.
It has to be objectively reasonable. We have to take into account the circumstances, information, the threat to the officer, the threat to others, the severity of that. So that is not part of our policy. That is not what we teach, and that should be condoned.
When do you believe, or do you have a belief as to when this restraint, the restraint on the ground that you viewed, should have stopped?
Once Mr. Floyd had stopped resisting, and certainly once he was in distress and trying to verbalize that, that should have stopped.
And earlier, prosecutors, they asked the longest tenured member of the Minneapolis Police Department, as well as head of its homicide unit, for his take on what Chauvin did.
What is your view of that use of force during that time period?
Totally unnecessary. Pulling him down to the ground, face down, and putting your knee on a neck for that amount of time is just uncalled for. I saw no reason why the officers felt they were in danger, if that's what they felt. And that's what they would have to feel to be able to use that kind of force.
Let's discuss this now with a man who knows the justice system in Minnesota as well as anyone, Tom Heffelfinger. He's an attorney in private practice in Minnesota. He's also former assistant Hennepin County attorney, that's Minneapolis. He's also former U.S. attorney for the District of Minnesota. Tom, initial impressions to this point, given both the testimony and the video we've seen time and time again, what kind of an impact do you think so far on the jury?
The videos, and there are multiple of them, have been extraordinarily compelling. The totality of the evidence that the prosecution has put together has been also compelling. So you combine the video with live testimony, and I think of that in two categories to this point. The bystanders who were witnessed this on the corner of 38th and Chicago, and the police testimony was also compelling, because it's not normal to see a series of officers from your direct supervisor to the chief of police testify that your behavior was inappropriate.
And speak to that, Tom, because to see senior officials, from the chief to people with long careers, uniformly, and I know this is just the prosecution portion of the trial to this point, but say that's not what we teach, that's not acceptable behavior, he didn't do it the right way, he didn't follow the book. You know, you're far closer to this than me, but that doesn't seem common in these kinds of cases.
It's not common. Not only is it not common in Minnesota, it's not common generally when you have prosecutions of police officers. Most police violence cases involve the use of a firearm and a instantaneous decision that a police officer has to make. This violence involved physical violence, use of body weight, knee to the neck, which lasted for 9 minutes or more. So there's what makes it different is that this police officer had a lot of time to deliberate on his actions.
I imagine, Tom, you still have friends, you know, in the legal system in Minnesota. I'm curious. Every law enforcement person I've talked to on and off camera, I'm surprised, and unlike other controversial cases, and as you mentioned, usually where gunfire is involved and a split-second decision is involved, that unlike those, in this case, they said, I can't for the life of me understand why he kept doing what he did for 9.5 minutes. Are you hearing that also in the legal community as well, to say, this one's not a jump ball?
First of all, I do know all of the people involved in this case. The judge is a good friend, public defender, the prosecutors. One of the prosecutors I hired as an assistant U.S. attorney. And to the legal system generally is having the same reaction to this set of facts as the general public has. The original airing of the video caught all of us aghast. And that has not let up as the evidence has come in. If anything, the compelling nature of the evidence has made the videos, I won't say secondary, but they are not the only compelling piece of this case.
Give an idea, pull the curtain back, the pressures, given the stakes of this trial, and obviously it's not, you know, this is not just about Minnesota, this is not just about Mr. Chauvin and Mr. Floyd. In many ways, policing on trial here on a national basis. What kind of pressures are the prosecutors facing right now, given the consequences of a verdict one way or the other?
I would go farther, Richard, and say that all of the participants in this trial are under a huge amount of pressure. It's not only Derek Chauvin that's on trial here and the Minnesota judicial system. It's all of us in our interaction with people of other colors and races. It is definitely a factor that communities of color have historically suffered from interactions with police, suffered badly. And this trial has brought all of those historical relations to the forefront. And as you saw after the death on Memorial Day last summer, Minneapolis led the nation, if you will, in the protests following George Floyd's death.
We know because we've seen, Tom, that the defense is trying to at least create doubt as to what was the overarching factor in the death of George Floyd, and we can expect to see much more of that when they put their case out. And also they'll introduce at least what they can of Floyd's troubled life before that day in Minneapolis. That said, do you think there's a temptation, given how the trial's gone to this point, to put Chauvin on the stand?
I don't know. And that's a great question. I think you'll be able to answer that question yourself, Richard, as you get into the conclusion of the prosecution case and you start seeing whether or not there is other evidence introduced by the prosecution from which the defense can argue Chauvin's intent, his state of mind, why he was doing this. I call back to a testimony of a bystander named McMillian a few days ago, who was testifying in connection with the body camera that Chauvin was wearing. And during that dialogue between McMillian and Chauvin, you heard Chauvin tell McMillian what he was doing and why. So that's an example of other evidence that can come into the trial, which may make it possible for the defense to lay out their case without putting Chauvin on the stand.
Well, I really appreciate, especially from your perspective on this, I think it's going so far, and also what you believe the stakes of this trial are. Tom, thank you so much. I appreciate it.
My pleasure.
Up next, the fight for infrastructure. President Biden hitting the road to sell his $2 trillion plan. Republicans, they don't like it. Big business, they don't want to pay for it. And now even some Democrats are saying, we'll fix our tax problem or we'll vote no. I'll speak with one of them, New Jersey Congresswoman Mikey Sherrill, next.